The anti-deficiency statutes in Arizona really apply to situations in which there are foreclosures. Okay, so I should make that point first and foremost. So two types of foreclosures in Arizona. One is a foreclosure by trustee sale, and the second is a foreclosure by a court proceeding, a lawsuit. Now this first slide addresses a deficiency balance following a foreclosure, where there's a deficiency balance following a trustee sale. The deficiency statutes apply specifically in these instances. The home is on a parcel that is 2.5 acres or less, and the home is limited to and utilized for either a single one-family or single two-family dwelling. Well, what does that mean? Well, what it means is that if you're a homeowner or a developer and your property is sitting on more than 2.5 acres, the anti-deficiency statute doesn't apply to you. What it means is that if you have a property that's being utilized for more than a single one-family or single two-family dwelling, the statute doesn't apply to you. In fact, there was some recent case law dealing with, specifically with whether or not it's utilized as a dwelling, as a single one-family or two-family dwelling. A homeowner that was having a property under construction and had the intention of moving into the property as his or her as a residence. And in that situation, actually, the court found that the anti-deficiency statute did apply, even though they didn't physically live in the property because the construction hadn't yet been completed. But the point is with this statute that following a trustee sale, if your question is, my home went through a foreclosure, it's sold at a trustee sale, can the lender come after me as the former homeowner for the deficiency balance? And what this statute specifically says is that if your home, as I said, if it satisfies these requirements in the statute, then under the anti-deficiency statute, the lender, I say can't come after you for the deficiency, but let me qualify that. The anti-deficiency statute is a defense. It's a defense to an action, a deficiency action, which is a lawsuit for a deficiency balance. And so it's not that the lender can't come after you, it's just that the statute is designed to protect you, designed to assist you in putting up a defense to a deficiency action. So this has to do now, this statute deals with foreclosures following trustee sales. I'm an investor in property. I'm not the homeowner. Can I still take advantage of the anti-deficiency provisions? And this slide indicates that yes, even as a developer or an investor, you can take advantage of the anti-deficiency statutes. With this caveat, if I'm a developer and I'm in the process of constructing properties, and it's my intention not to live in the properties, but rather to sell them off to some subsequent homeowner, then arguably you don't satisfy one of the prongs of the anti-deficiency statutes, which is to say that it's being utilized as a single one-family or two-family dwelling. This also says that you can be an investor. This statute doesn't require you to be the actual homeowner, if you will. Some people say, well, does it have to be my primary residence? Do I have to be the person who actually owns the property and lives in it? No, that's not the case. You can be an investor and still take advantage of the anti-deficiency statutes. Okay. Under the trustee sale anti-deficiency statute, there's no purchase money mortgage requirement. So what that means then is if your home is foreclosed via trustee sale and there's a deficiency balance following the trustee sale, if you satisfy only the two of those requirements that I mentioned earlier, the two requirements being on a parcel that's 2.5 acres or less, and the home is limited to and utilized for either a single one-family or single two-family dwelling, then you satisfy that anti-deficiency statute. There's no purchase money requirement following a trustee sale when we're dealing with foreclosures and anti-deficiency statutes.
Thank you. I think we all need to see you before we head down a path.